Uh, and you can unmute yourself.
Okay. Hi, my name is Shauna Huey, and I am an MA candidate at the University of Guelph. And today I'm going to be talking about an article that I wrote about the impact of Supreme Court decisions on sexual assault legislation. Specifically in this study, my research question was, how have the 6 major sexual assault cases at the Supreme Court and external factors influenced the current sexual assault legislation that was introduced in 2018? So in doing so, my methodology, I essentially examined the 6 major Supreme Court decisions, as well as the feminist discourse surrounding it, and then the public reactions and social media movements surrounding sexual assault. And in doing so, I examined the parliamentary debates to see what influenced the parliamentary debates in creating this new piece of legislation. So in doing so, I found that there are primarily 3 categories of change in Bill C-51, which is the recent amendment to the criminal code. And the first being the rape shield provisions. And essentially the rape shield provisions, it doesn't allow the use of the past sexual history of the complainant to be used as evidence at trial. And this was dealt with at 2 Supreme Court cases in R.V. Seaboyer and R.V. Game in 1991. And specifically in this case, it challenged the rape shield provisions outlined in section 276 and 277 of the Criminal Code of Canada. And in a 7-2 decision, section 276, which outlined the rape shield provisions, was struck down, and the appeal was ultimately dismissed. And then Parliament responded with Bill C-49 that ultimately changed the definition of consent to discourage the use of the past sexual history of the complainant as evidence. However, the rape shield was ultimately struck down, and there was kind of a policy vacuum. This new law was then challenged in R.V. Derrick in 2000, in which the amended 276 was challenged. And in a unanimous decision, the court upheld the new law that adhered to the Seaboyer decision, that the rape shield provisions violated the constitutional rights of the accused at the trial level. The second category of change in sexual assault law is the use of third-party therapeutic records of the complainant as evidence at trial. And this was dealt with again at 2 cases at the Supreme Court, and the first being R.V. O'Connor in 1995, which focused on the admissibility of therapeutic and medical records of the complainant as evidence. And in a split 5-4 decision, the Supreme Court argued that excluding the use of third-party therapeutic records ultimately violated the rights of the accused to a fair trial. Whereas the dissent, which was authored by Justice Laura Dubé, who is one of the female justices, argued that in using the therapeutic records of victims, this ultimately perpetuated rape myths that are common at the trial level in sexual assault cases. Following this, Parliament responded with Bill C-46 that did reflect the dissent, which was then challenged in R.V. Mills in 1999, in which Brian Mills challenged the newly amended Section 278 of the Criminal Code, that reflected the dissent. And in a 7-1 decision, the law was upheld and was ultimately praised by feminist scholars as it reflected the dissent that was more geared towards protecting victims rather than protecting the rights of the accused. The final category of change that Bill C-51 addresses is in the definition of consent. In R.V. Ewanshuk in 1999, this case at the Supreme Court dealt with the issue of implied consent and challenged section 265 of the Criminal Code, which were the consent provisions. The Supreme Court ruled in a unanimous decision that the defense of mistaken belief of consent is not a legitimate defense, and consent must be active and affirmative. This decision was praised by feminist legal scholars for expanding the definition of consent in terms of active and affirmative consent. And then the most recent case in terms of sexual assault cases at the Supreme Court is RVJA in 2011. And this case dealt with the issue of prior consent, of whether or not you can consent prior to a sexual act, and whether or not this should be deemed sexual assault. And the Supreme Court ruled in favor of active and affirmative consent, in that you not only need prior consent, but you need consent at every stage of the process, rather than just one consent that should be adhered to for the entire sexual act. Following this, I examined the Supreme Court cases, and then I wanted to examine the feminist discourse surrounding these, as well as the issues that arose in terms of the criminal justice system, as well as external pressures that influence the amending of sexual assault provisions. So specifically, in terms of the feminist discourse, I found that the primary issue addressed was not in the cases themselves, but rather the lack of resources that are being given to address the systemic issues in the criminal justice system. For example, there is a big impact of gender stereotyping in trials, and this idea of the ideal victim is often used as a trope to discredit women. This is the idea that unless you are a white woman who is attacked by a stranger, it is not a legitimate case for sexual assault. Additionally, many feminists have found that there are rape myths that are prominent at every stage of the trial process and are often used by defense attorneys as well as police officers, as well as there's too much discretion given to trial judges where they can perpetuate these rape myths. Finally, I examined that the social movements in Canada as well as internationally to determine if there is an impact, whether they impacted the new legislation. So specifically, I looked at the hashtag #MeToo movement, which is an international Twitter movement surrounding sexual assault and harassment, as well as the Gomeshi trial, which sparked national outrage in terms of how victims were treated at the trial level. This is just a quick legislative summary of Bill C-51, which is the new amendments to the criminal code. And specifically this legislation deals with changing the definition of consent. It amends the rape shield provisions, as well as it changes the definition of a private record. Now, in conceptualizing where this bill fell in terms of the external factors, there's often competing rights claims between the rights of the accused, as well as the rights of victims. And once you take the rights away from one, or once you give rights to one group, you're taking rights from the other group. And the Supreme Court has often been trying to balance these rights. So specifically in terms of the amended private records, Bill C-51 expands the definition of private records to all communication in the hands of the accused that pertains to the complainant and witnesses. So in doing this, this goes much further than the Supreme Court jurisprudence, as the complainant is now allowed to object to the admissibility of a private record that pertains to them. So it goes much further in terms of expanding the rights of victims, as you can see on this chart here. And at committee, feminist scholars were very split on this issue, as it ultimately created a much more inaccessible justice system, and it provided no resources to help victims navigate this increasingly difficult criminal justice system, which will ultimately decrease reporting rates. Whereas some feminist scholars argued that this was a good thing, as it ultimately expanded victim rights. However, legal scholars were not divided on this, and they argued that this new piece of legislation was unconstitutional as it violates the rights of the accused to a fair trial. Secondly, the rape shield provisions were amended in Bill C-51, and that now requires the accused to make an advanced disclosure on the use of evidence regarding the sexual history of the complainant. And again, this new amendment goes much further than the Supreme Court jurisprudence, as outlined in R.V. Seaboyer, as well as R.V. Derrick. And it goes much further in terms of protecting victim rights. And most feminist scholars at committee were not divided on this issue, that it was ultimately empowering to victims. However, legal scholars argued that, again, it violated the rights of the accused to a fair trial. And then the final aspect of Bill C-51 was in changing the definition of consent, in adding the term unconscious in the definition of consent. This was an issue that was not divided at committee between legal scholars as well as feminist scholars, as it goes much further than not only expanding victim rights, but it goes too far, many have argued, in that by adding the term unconscious, this ultimately creates a higher threshold of consent. It ultimately creates a higher threshold of consent by creating a narrower definition of incapacity. And ultimately, this doesn't codify the Supreme Court decisions, as RVJA dealt with the ideas of prior consent rather than consent and unconsciousness. So in terms of my conclusion, the influences on Bill C-51, there were very superficial influences in terms of the Supreme Court jurisprudence, as well as the social media movements, in which this bill, it was often They often cited the Me Too movement as well as the Ghomeshi trial, but it did not address the systemic issues in the criminal justice system. And ultimately, this study demonstrates the institutional limitations of the criminal justice system as it becomes a much more difficult system to navigate for victims with this new amended legislation. And finally, in terms of adding unconsciousness to the definition of consent, not only is this not a superficial change, this is a superficial change and kind of a band-aid solution, it will ultimately result in women being targeted. And that is my presentation. Thank you for listening.
Thank you so much, Shauna, for a wonderful presentation.